It's partly allowed by modifying consent.
Item 2.
This is also partly allowed by modifying consent.
Item 3.
It's partly allowed by modifying consent.
Item 4.
Appeal is allowed by equity.
Item 5.
It's partly allowed.
Item 6.
Partly allowed by provision.
Item 7.
It's partly allowed.
Item 8.
Partly allowed.
Item 9.
Partly.
Item 10.
It's allowed.
Item 11.
Partly allowed.
Item 12.
Partly allowed.
Item 13.
Dispose of with certain observation. Yes.
Any mention?
But I am filing a written argument. But that 370 case, so the age variation, my lord. My friend, my lord, also assisted me a lot. And he written argument.
Judgment is reserved.
Judgment is reserved.
Okay.
I may be pardoned to mention, Your Lordship. Your Lordship, item number 62.
Yes.
Your Lordship, I haven't received the proper copy, which is completely not readable, Your Lordship. Your Lordship, can it be fixed for
60?
next week? 62,
62.
Your Lordship. Yes, Your Lordship.
If it is not readable, how will you read it next week?
Your Lordship, I'll be receiving the copy from the sections, the proper copy, Your Lordship. I have only received the soft copy, Your Lordship.
Just check it, a proper copy. 62 hard copy. Thank you. 62.
Oh.
120 of 2009.
TCR my lord. TCR soft copy. TCR
Hard copy is not there. We have only soft copy. You have to come and see. If I don't know.
Your Lordship,
Not-
can it be fixed for next week, Your Lordship? I can arrange the copy, hard copy from the court itself and go through it, Your Lordship.
But if you see the soft copies are legible here.
No, Your Lordship, the copy which I have, it is completely not readable, Your Lordship.
Then from you have to get assistance from soft copy. These are legible.
Yes, Your
Legible.
Lordship. Your Lordship, can it be fixed for next week?
Okay. Next, please. It will remain in the list. I'll take it up next. Okay.
Okay, oblige, Your Lordship.
Yes, Mr.
Item 37.
37.
It's completed on a phase of 3 minutes. 1 is restricted for it.
30?
37.
Yes.
Completed on a phase of 3 But in 1 year restricted for the or 142 days already on the and ready.
Are you interested to argue?
Yes, sir. At this.
Okay, well, here, let us see. Wait for some time. Yes. Yes, anybody is there? Reports are there, na?
No, sir, weekly list. Sorry, item 7.
17.
17 no.
Item 7.
7.
Last one.
Who is there? Let us see, because today, who is there to argue? Mr. Naik,
Item
Ready?
15, Your Lordship.
which one?
Item 15.
15. Argue, please, sir. Give the file. That's here.
Written note of submission.
Yes. Yes. Just run through the written note. Just run through. Have you given the copy? Which Mr. You are, just run through the.
Yes, sir.
Yes.
So this case is challenging the conviction under section 341 and 376 of IPC for sentencing him to undergo simple imprisonment for 1 month, rigorous imprisonment for 7 years, with fine of rupees 500 and rigorous imprisonment for 1 month. The date of occurrence is, Your Lordship, 29/1994, and the complaint case was filed 7 days after. Police station is Bodasai Police Station. It is in Baripada, Your Lordship. Section that has been convicted under is 341 and 376. Your Lordship, the prosecution story is there. PW1 is the lady doctor who examined the victim. PW2 is the elder brother of the victim. PW3.
Read the prosecution story on the.
Direct, sir. The
Read,
fact of the case.
Read it.
Yes, sir.
Page 2.
Yes, sir. The fact of the case is,
Hmm.
on the date of occurrence, the alleged occurrence at about 8:30 p.m., the victim, along with PW3, who is her cousin, was returning from the village after purchasing chenachur.
Hmm.
It is alleged that the appellant suddenly appeared on the village road, covered the mouth of the victim with a cloth, forcibly took her to a lonely place and committed rape. It is further alleged that the victim was
Yes.
And in this case, my lord, President appellant was facing trial under section 302 and 34 of IPC, my lord. The committing murder of this is Gopal Naik, but convicted under section 323.
323 only.
My lord.
Charge was 302.
Yes, my lord.
Ah.
And sentenced for rigorous imprisonment for 1 year, my lord.
Hmm.
And in the meantime, my lord, undergone 142 days, my lord, already undergone. Already undergone 142 days, my lord.
142 days.
My lord. 2 accused persons were there, my lord.
142
My lord.
days means how many months? So 4 months something.
My lord.
4 months something. Eh?
4 months.
We are for the informant in this case.
Yes.
Informant. 2 accused persons were
Shall I
there.
grant you probation?
But
See, three, about 4 months you have already undergone.
yes, my lord.
1 year sentence.
My lord.
So I'll grant probation if you want.
But I would like to read only 2-3 evidences, my lord. Because no eyewitnesses there, my lord.
I mean, you are aiming at a acquittal.
Yes, my lord.
Read it. Yes. There was no eyewitness according to you. Okay.
Basing on the evidence of PW 3 and 5, the Lornet Session Judge Khorda convicted under section 223 mallet, 323 mallet.
Who is injured?
Injured person is mallet. This is Ganesh Naik.
Deceased.
Yes,
He
madam.
died. Huh?
Died. Ganesh Naik. Other than no injured person.
No eyewitness.
No eyewitness.
What is the reasoning given by the trial court by acquitting you 302?
302 on the 302 on the basis that no eyewitnesses there with regard to 302 mallet, and only basing on the statement of PW3, who says that the accused person, the present appellant, two accused persons were there. One is Papuli alias Soumya Prakash Das, who is the appellant in this case. Another one, Amar Mahanti, who has committed suicide soon after the occurrence, my lord.
You only face the trial.
Yes, my lord. I am only facing the.
Soumya Prakash Das.
Yes, my lord. Amar Mahanti already committed suicide.
Okay, he was another accused.
Another accused, my lord.
Okay. Let us see.
Immediately after the occurrence, my lord. On 23/9/2000, the occurrence took place. On
23/9/2000.
2000. The occurrence took place.
Correct.
And on 24/9/2000,
24/9/2000.
Amar Mahanti committed suicide.
More.
Another accused person.
Who is it? Suicide, huh?
My lord.
Okay.
Prosecution story like this, my lord. The deceased owned a 3-room shops house at Shahid Nagar Weekly Market Hat, where from two places, namely Bipin and Bancha, were running shops. The deceased used to visit his shop house on the weekly market day. In the evening of 23/9/2000, he had been to Shahid Nagar Weekly Market, and at about 9:25 p.m., while urinating by the side of 12 near the compound wall, the accused appellant and his accomplice taunted him, leading to an altercation between them. The deceased came to the shop and shop room, leased out to Bipin, being followed by appellant and his accomplice. They pushed the deceased, as a result of which his head came in contact with the door latches, causing injury. The appellant and the accomplice forced
Okay, so come to PW3.
PW3, my lord.
I know this is Gopal Naik and the
Right.
accused and the dog, that is you. The occurrence took place at 9:30 p.m. on 23/9/2000 at Said Nagar Market. I had been to Said Nagar Market at the relevant time to purchase vegetable and was purchasing the vegetable from the shop of Bapin Bihari Naik. This is Gopal Naik had got shop house huh?
Shop.
At the Said Nagar Market consisting of 3 room and which he had tenant, and he used to visit his house on weekly market day. The rooms are shop rooms. At the relevant time, I found the deceased Gopal Naik standing in front of his shop room. The accused and other persons went there, and there was a quarrel between them. And Gopal Naik, accused and his accomplice with Gopal Naik, as a result of which he was dashed against the door frame of the house. As a result of which
Page 2 is relevant, my lord.
on the
bottom.
back of his head over the left ear, and he intervened to separate the accused and his accomplice. But the accused and the accomplice threatened with dire consequences. In the meantime, the deceased fell down, and the accused and the accomplice dealt him kick and fist blows on his abdomen, chest, and back. Thereafter, the accused and his accomplice cut hold of the hand of the deceased Gopal Naik and dragged him to Arisama's situated to the distance of 50 cubic, and there also the accused and accomplice dealt fist blow and kick blow the abdomen and chest also. many people gathered to see Arishwal, but then all the people gathered, like, the companies left the place and so on. So this is Gopal was so plain and blood oozing from his nostril and some one in all.
Last four paragraphs, 4 lines, my lord, of the deposition. He says that we shifted the deceased to the auto rickshaw of PW1 in order to take him to his home at village Korodakonta on 24/9/2000. And this is succumbed to the injuries, my lord. The PW3 and 5 says that they shifted to the deceased to the auto rickshaw of PW1. What PW1 says, my lord? PW1, my lord.
But PW1 says
This is the auto rickshaw driver, my lord.
he is the auto rickshaw driver. He has taken.
Yes, my lord.
I know Gopal so and so, occurrence took place so and so. I was present at the rickshaw stand and 20 years proceeding at about so and so. On my way home, I went to Saidnagar and purchased vegetable. When I returned from the auto rickshaw after purchasing vegetable, I found that this is Gopal Naik was attended in my auto rickshaw. I had carried him so and so, and he walked out to the rickshaw and went to the house. But the fact is, he carried the disease.
My lord.
He
But
says
he doesn't says about that the PW3 and 5 shifted the deceased to the
he was declared hostile, but that part of the evidence is there.
let's see the IO. What IO says, my lord, paragraph 11 and 12.
Where is the doctor's evidence?
Doctor evidence, my lord, PW2. Doctor is Santosh Mishra. Again. I conduct.
But the dead body was addicted to me and this is my found the following internal evidence.
Paragraph 3.
Not accepted on the right
Liver. Live.
lateral.
See, para 4 of the doctor, if you see on
Yes.
25/10/2000, the IO made a query whether the internal injuries noticed by me could have been caused by fist or kick blows, and whether the injuries can cause the death in the ordinary course of nature.
Well.
Exhibit 3 is the query.
Yes.
I replied in affirmative.
I agree with 3/1 and 2 initially.
There is no injury on the abdominal wall and all these things. This is the kind of evidence you have. And why the trial court has not convicted you in a higher offense? Let us see. What is the reasoning? What is the reasoning? It was a homicidal death. Then why 302 is not made out? Hmm? Come to para 10 of the judgment.
My lord. Both the PW 3 and 5 has stated that the accused and the accomplice pushed the deceased at the short room as a result of which his head was dashed against the door, thus causing injury on his head over the left ear. But the doctor doesn't say about any injury at the head by that.
Para 10, there is no logic. There is no major discrepancies in the evidence of PW. See, the evidence of PW 5 and 3 and 5
Right.
directly corroborate with the evidence of the doctor PW 1, PW 2.
By that.
And that's what the trial court also says.
By that.
And having said that, you have been convicted under 323. And you should be happy that the state has not come against you. State should have come.
Kindly have a glance to the
Where is this? There is a the direct find this is a homicidal death. And the trial court says that in the present case, PW2, the doctor conducting a autopsy has opined that the injuries to the liver and transverse colon, as noticed by him, are possible by kick and fist blow, and which lend assurance to the ocular testimony of PW3 and 5 that kick and fist blows were delivered to the abdomen of the deceased. Liver damage.
that can be. But
If that is the evidence of the doctor.
PW
And so therefore it is a case of homicidal death. 323, you should be happy. The state should have come.
Yes, but this present appellate
It is very old appeal, 2002 appeal. Otherwise, this is a case where for enhancement of sentence, notice should have been issued by this court.
IOR shall take it on ballot paragraph 11 and 12.
Discrepancy in the place of occurrence.
Yes, ballot. The PW3 has not stated before with that the accused
Everybody says the market.
40 to 60% were there, ballot. But
Maybe that the trial court says that deliberately withheld. If see, quantity of evidence is not required, the number of witnesses examined is enough. See, come to the trial court what he says. This is completely wrong. Right. It says that deliberately withheld. That's the outlook of the prosecution. If they can prove by bringing 2 witnesses, let it be. Para 11, if you see, there is no major discrepancies in the evidence of PW 3 and 5 regarding the place and the time of occurrence and the manner of assault of the deceased, and the inconsistencies in their evidence as to the discredit them and to affect the substratum of the prosecution case in the case of the state of so and so, so and so, so and so. In the present case, there is no glaring discrepancies or inconsistency noticed in the evidence of PW 3 and 5. On the other hand, the defense admits so and so, Amar, since disease was assaulting the deceased at the height of so and so, so and so, Amar has died. PW6 is the brother of the deceased.
PW3 and 5 both are the brother of the deceased, ballot.
No, this is not a case. Evidence there. This has to be dismissed. You should be happy with whatever is happened first.
PW3 and 5 କହୁଛନ୍ତି ତାର ear ରେ nose ରେ ତାପରେ ତାର head ଉପରେ injury ହେଇଛି. But doctor is not saying that, ballot. Head ରେ injury.
Leave that apart.
Ballot.
And the doctor finds you have given kick blows and fist blows.
My lord.
on the abdomen.
My lord.
Doctor makes a very specific
Minor.
statement
My lord.
that because of the kick and fist blow, the liver is damaged.
That is admitted, my lord.
Then
But my lord, the involvement of present
merely
applicant-
because the other injuries are not there, head injuries, he fell down. And
He-
the trial court also says 5 and 3 and 5
Madam.
statement is consistent.
not consistent, my lord.
Consistent.
My lord, scientist.
Consistent.
My lord, PW 5 में kindly see, my lord.
Para 11, read it.
My lord.
Para 11 of the judgment.
Judgment.
Yes. Yes. Page 10. The judgment. Page 10 of internal page 10 of internal.
My lord. I'm reading, my lord.
That's possible by kick and hit blow.
Yes, please.
He can control the demand to be at visit. Therefore, it cannot be stated medical evidence. None of the actual is inconsistent with the ocular evidence, only because of the doctor not notice a minor injury on the head of the visit.
The para 15, just see. Para 15, read para 15. This is the reasoning for 320.
My lord.
Read it.
From the discussion.
From the discussion made
reasons taken.
and reasons stated in the foregoing paragraph, I hold that the accused and his accomplice, Amar,
My lord.
have assaulted the deceased on his abdomen, chest, and other part of the body by delivering kick and fist blows. Ordinarily, death is not caused by the fist blow and kick blow, as it cannot be said to be either the accused or his deceased accomplice had the intention of causing death to the disease. This opinion is contrary to the doctor's opinion. How he substitute? He says the ordinary course it can cause death. That's what the doctor says. And they had also no intention of causing bodily injury as likely to cause death. What they did is first in the room they have beaten him up.
My lord.
They drag him to another place, Arya Samaj, and there also again they kicked him and assaulted.
But, there is no injury triggered.
At that time he was already bleeding. So where from the trial court arrived at this function?
PW 5 alert in paragraph 5 says, I arrived at the scene of occurrence near the 12 fast. No other persons had reached the place at that time. There was a gathering about 40 persons when the accused and his accomplice assaulted the deceased at the stoppage at his shop house. Alert. He says, alert, no other persons are reached at the place at that time. Alert. Where PW 3 says he was present. PW 5 says he was present. Alert. And the doctor, IO says both PW3 has not stated before me that the accused and accomplice dragged the deceased by holding the hands, and he has stated that they dragged the deceased pilot. So paragraph 12 also, it is a fact that PW5 has not specifically stated before.
Come to the doctor, PW2. See the second injury. Second injury.
PW2 is the doctor.
PW2.
Doctor. Second injury.
We found that following internal injury.
Hmm.
One, laceration on the right level of the liver.
That's a minor one, no problem.
Minor.
Next one.
Transverso
Transversocolon
colon
was
located at
at the middle, at the
Side of-
side
Site of
of transversocolon attachment,
attachment.
admitting tip of the little finger. Transmescolon was torn, corresponding
Along with the injury to blood vessel,
along the injury to the blood vessels.
abdominal
A-
cavity
Cavity
was
was filled with 2 liters of
The
blood
blood.
and
contaminated
contaminated with
with physical matter.
physical matters.
blood.
This is the blow you have given to the abdomen. This is the cause of death. And how the doctor says that in the ordinary course there was no intention. The ordinary course, the fist blow and the other blow will not cause death.
And two, Roman two, the cause of death was due to the hemorrhage and shock resulting from injury to liver and transference to colon.
Leave it here. Otherwise, I have to issue notice
Exactly.
for announcement. This is a case of 302. You should be happy with. Don't press it. Otherwise, state should have filed a appeal. Otherwise, I'll issue notice. I'll tell you. This is the trial court is absolutely wrong. 302 case. 302 case. This is old matter, therefore I am not issuing notice. Otherwise, I should have issued notice to you why the conviction shall not be altered to 302. Or I can remand it back to the trial court.
142 days already when undergone ballot, provisional for.
No question of provision. I'll enhance the sentence. That's the first of all I told you. I gave that option. You didn't opt for it. You made me to read all these things. Made me to read all these things. Better that I shouldn't interfere at all. This is a clear-cut case for enhancement of the sentence.
But the involvement of the person is could not be found out. The injuries
What
are
is,
there.
what is the reasoning in paragraph 15?
Well.
The trial court become the expert. The doctor says something, he says something else. Just see paragraph 15. Will you go with that? Will you go with that reasoning? You tell me. He says that in the ordinary course of these injuries will not cause death.
Injuries
It
is
is.
admitted.
It is. That is the opinion. He read it out.
Because that another person, Amar Bhani, already committed suicide soon after that, the occurrence.
That may be for some reason. We don't know.
See, 24 मला ये भी है 24 रे जाएंगी रेलवे स्टेशन में बच्ची committed suicide pellet.
Who?
That Amar Bhani pellet.
Maybe that's maybe reason. But these are the evidences.
The defense also admitted that the Amar Bhani accidented pellet. That person's involvement is not there.
That has not come anywhere. There is no suggestion, nothing. You have not put any suggestion also. Was there any case registered for 306 or anything of that sort?
No matter.
Then that story is something different. Leave it here.
Right.
Leave it here. Huh? I think it's very difficult. Okay.
Obliged, man.
Then anyone who is ready? Ready, madam? 12 o'clock will here? Yes. 44 only.
ଅଳ୍ପ ସମୟ ନବ
47 time.
ଅଳ୍ପ ସମୟ
ନାଇଁ ନାଇଁ ମୁଁ
40?
ବେଶୀ ସମୟ ନେବି କେବଳ ଟେକ୍ନିକାଲିଟି ଦିଟା କେବଳ ଆପଣଙ୍କୁ ଦେଖେଇଦେବି ଆଜ୍ଞା ମୁଁ 15 ମିନିଟ୍ ଭିତରେ ସାରିଦେବି
କଣ offense?
ଏଇଟା
Offense.
ହଉଛି 20B2 NDPS Act 5 କେଜି କେବଳ ସେମାନେ ବ୍ରାସ୍ ସିଲ୍ ପ୍ରଡ୍ୟୁସ୍ କରିନାହାନ୍ତି ଗୋଟେ ଆଉ 42ଟା କମ୍ପ୍ଲାଏ କରିନାହାନ୍ତି କାହିଁକି ସନସେଟ୍ ରୁ ସନରାଇଜ୍ ଭିତରେ ଚଢିଲେ ଗାଡି ଭିତରେ ସେଗୁଡା ସେମାନେ କିଛି ଦେଖେଇ ନାହାନ୍ତି ଆଉ ଯୋଉ ତାପରେ ହଉଛି ସେଫ୍ କଷ୍ଟଡିଟା ସେ ଯୋଉ 2 ଦିନ ତାଙ୍କ ପାଖରେ ରଖିଲେ ସେ 2 ଦିନକୁ ସେମାନେ ଏକ୍ସପ୍ଲେନ କରିନାହାନ୍ତି ସେମାନେ କହୁଛନ୍ତି ଯେ ଆମେ ରଖିଛୁ ତାକୁ PS ମାଲଖାନାରେ with entry କିନ୍ତୁ ସେଟାକୁ କୋର୍ଟରେ ପ୍ରଡ୍ୟୁସ୍ କରୁନାହାନ୍ତି ମୋର ଏଇ ତିନିଟା ସମିଶନ କେବଳ
These are the technical problem, technical issue.
ଟେକ୍ନିକାଲ ଆଜ୍ଞା
I'll be here up to just after 12 o'clock. I'll come here.
ହଁ
And you come at 2 o'clock. That's I'll hear, madam.
ତାଙ୍କର ଅଳ୍ପ ସମୟ ନେବ ମୁଁ ଦିଟା ପୂର୍ବରୁ ସାର୍
How much time will you take, madam?
ସିଏ କହୁଥିଲେ ଯେ ମତେ ଆପଣ ସାର୍ କରିଦିଅନ୍ତୁ ଆଗ ବୋଲି
Huh?
3 years,
ହଁ
1 year.
କରିଦଉନାହାନ୍ତି
385, 1 year, 200. 7 days on the
I can hear both of you.
Oh.
I'll come on.
ଆଜ୍ଞା ଆଜ୍ଞା
47 hours. NDPS.
Okay, I'll hear you. Get ready. Get ready.
ଅଳ୍ପ ସମୟ ନେବ।
Get ready.
For
I-
3
I
matters,
consider-
3 matters in line up. Yes.
This one the 5 year 50,000.
Are you ready? 5 years, 57.
80 kg.
With the,
80 kg.
see, the sentence is 5 years. So therefore, prepare your written note of submission and all. You had that.
Written note I have not prepared, but I am ready with the case.
Okay. I'll just.
ଆପଣ ଯୋଉ ଜଜମେଣ୍ଟ ଦେଇଛନ୍ତି ଗୋଟେ ସିଆରେ
I might have committed a mistake. I
ନାଇଁ
can't
ନାଇଁ
find
ନାଇଁ
an answer.
ମିଷ୍ଟେକ୍ ହେଇନି ସେଇଟା ମୁଁ ରିଲାଇ କରୁଛି ସେଇଥିପାଇଁ ବୋଲି କହୁଛି ଯେ
I'll just come and I'll hear you first. Thereafter, madam, I'll. Huh?
ଆଜ୍ଞା
First, I'll hear you. Thereafter, I'll hear.
ଆଜ୍ଞା
madam.
ଆଜ୍ଞା
Okay. Okay.
ଏଇଟା କୋଉଟା ଆଜ୍ଞା
Yes.
Item 7. As per the order affected successful 6 matter, both the parties matter agree to appear.
I have taken instructions. I have taken instruction from the.
Which item you are talking?
Well, it's item 7.
Uh-huh.
Malats, I have taken instruction from my client. Malats, we are willing to participate in the mediation proceeding. Malats.
Mediation.
Malats. But Malats, however, should I make a prayer? Malats, Malats, by virtue of order dated 16/12/2025, Malats directed that in case 9 lakhs is being submitted before this honorable court, 5 lakhs must be disbursed in favor of the wife, and then 4 lakh must be retained. Malats, I pray that the same may be disbursed in favor of the wife. Why? Because Malats, till date, no maintenance has ever been paid. No, not a single penny, Malats.
Will be settled and the present petition also agree. Whatever the minors are, as per minor, if the permanent alimony finalized, then minor
That will be.
That would be
That
adjusted.
4 lakh will be adjusted.
Adjusted,
I'll
Malats.
say that.
That full-
Pursuant to the order dated 16/12/2025, you have deposited, na?
deposited.
Check. You have given 2 checks.
Two checks were
Checks.
deposited. One is blank.
The appellant has furnished 2 checks bearing number so. A letter counsel for the opposite party submits that as per the direction dated 16/12/2025, 4 lakhs out of the 9 lakhs to be deposited by the appellant shall be disbursed to the.
Well, it's 5 lakhs to be disbursed, 4 lakhs to be retained, is what the order stated.
5 lakhs shall be disbursed. 5 lakhs shall be disbursed to the opposite party wife. Hence, he prays that in pursuance to the said order, the check number so and so furnished by opposite party say petitioner is this check may be given to, handed over to the opposite party through him. Both the counsel appearing for the parties have conjointly submits that there is a scope of out of court settlement, and therefore they request to refer this matter to the High Court Mediation Center. High Court Mediation Center. The council, both the councils are directed to appear before the mediation center on 26th of February, and the coordinators shall fix appoint a mediator and fix date date before the mediator, which shall be intimated to the intimated to the parties to this proceeding by their respective council, and after respective council puts up after exploring the possibility, exploring this settlement, the coordinator shall file a report before this court. The 5 lakh rupees which has been disbursed to the opposite party shall be factored into the final amount of alimony to be decided. Decided.
We are willing to cooperate.
Expected that
Both the parties.
both the petitioner and opposite party will cooperate with the mediation process. Right? If you would review, then I'm giving it back, the blank check which you have given.
Lordship directed on the name of the one, and another is the director. If the Lordship permit before the deportation, before the Honorable High Court Orissa, if the Lordship.
No. See, now since you are going to for mediation, ultimately whatever you decide, that will be 5 lakhs will be adjusted, remaining amount you will pay. So you take it back. No, there was
there was a direction. There was a direction on us that 4
Let
lakhs
it
be deposited in a fixed.
So the blank check of 4 lakh rupees furnished by the petitioner shall be retained by retaining the file. Release the matter immediately after the mediation report is prepared and submitted before the court. Yes. Yes, sir. 30.
44. I may please, my lord. In this case, my lord, allegation of the petitioner, the appellant was traveling in a bus, and the PW1 entered inside the bus, and at the seat number 33, the appellant was sitting. The PW1 says that he was carrying a bag in which ganja was there, and was emitting smell of ganja. Thereafter, he asked him, my lord, my lord, can I see the evidence of PW1? That without wasting my lord's time and taking to the relevant portions. On 3/3/2003, the PW1 I'm placing. Noted and
Yes, what do you say?
my lord. Here my respectful submission is that the provisions, mandatory provisions of section 42, section 50, and section 55, they have not been complied with, my lord.
Come to 50 first. How do you say
My
50
lord,
is not complied?
yes, my lord, exactly, I'm coming to
Yes.
that. My lord, my lord, may kindly see the PW1,
Yes,
evidence of PW1,
yes.
paragraph 1.
Hmm.
I'm straightway taking my lord to the evidence what he has deposed.
Yes,
my
yes,
lord.
no problem. Hmm.
I disclosed my identity to the accused and wanted, whether he wants to be searched by me or before a gazetted officer or an executive magistrate.
Hmm.
Accused wanted to search in presence of a gazetted officer. That is the evidence of PW. No written requisition is given to the accused. My lord.
But gazetted officer came.
Yes. My lord.
If the gazetted officer would not have come, then in that case the written.
How the accused will know, the appellant will know that he is a gazetted officer, my lord. Exactly that my lord, held in criminal appeal number CRA. I'm relying on a decision of my lords, which is exactly akin to.
No, let us see. The first you have
Again, reading of the
PW1 you have read it. Huh?
again.
Yes.
My lord, sit down. Reading of evidence. This is the evidence so far as section 50 is concerned, my lord. Except that no other evidence is there, my lord.
No. See, come to PW1 itself. It says that
My lord.
just finally NC Singh, DSP crime,
My lord.
Raigada arrived at the spot at
My lord.
3:30 am. And in the presence of DSP, we all gave our personal search to the accused,
my lord,
and disclosed our identity.
I disclosed that identity.
Yes.
Right. Then
how do you know? He knows. He disclosed the identity.
he disclosed means the PW.
DSP disclosed.
The PW disclosed his identity.
No. All of them disclosed the identity.
We all gave our personal shots to the accused and disclosed our
identity.
Like my lord,
Including DSP.
my lord. First I weighed the bag, sir. Then I sealed the bag and found ganja to have been kept in a polythene bag. The ganja was weighed with the polythene bag and it was found to be
5 kg, 250
200 grams. Then the bag was removed and the ganja was homogeneously mixed and was weighed and it was found to be 5 kg. Then I prepared the sample packets weighing 24 grams. I sealed the sample packets and so also the rest ganja in the same canvas bag. The canvas bag was sealed with the help of lysine. I prepared the seizure list. This is then
Count to PW9.
Yeah.
PW9.
PW6.
PW9.
PW9. नहीं वो बस ये देखिए PW9 का और देखो मैं वो पे करना है कि PW9 हाँ
44
अपील नंबर टाला
PW9
हाँ 342
first paragraph.
On 3/8/2003, I was the DSP.
That is NC Singh, was the gazetted officer. Yes. Raigada on that day.
Yes.
As per the direction of SP Raigada, I proceeded to the spot and Siriguda Junction and SI so Swai detain a person carrying one khayni bag and who was traveling in the Happy Night bus. That bus was playing with Koraput towards the Raigada. I gave my identity. The SI police also gave my identity to the accused. He gave identity and SI police also said that he is the identity of.
In my presence.
In my presence, SI
conducted
personal
search
search
of the accused. After giving our personal search, nothing.
Your first argument is answered.
Recovered from his person.
Then my lord mechanism. It will come. Then in that case also, my lord, reading the evidence what my lords have held in the criminal appeal 195 of 1998. Reading the evidence of PW1 makes it clear that there was no written offer made to the accused intimating him regarding his right under section 50 of the NDPS Act for getting searched in presence of a magistrate or a gazetted officer. It is also evident that whether the IIC GP Das is a gazetted officer or not is obviously not known to the accused. That holding that also, my lord, acquitted the appellant.
But here identity is given.
My lord. Then with that PW1, my lord, make us see the towards last. Towards last. This is the sample towards middle, my lord, my kindly see. This is the sealed packet containing ganja recovered from the accused marked MO1 towards middle. ମଝିରେ ଆମେ ଯୋଉ ଛାଡ଼ିଥିଲେ ତା ପରବର୍ତ୍ତୀ. This is the sample packet marked MO2. The other sample packet was sent to RFSL Berhampur for chemical examination. This is the sample packet received from RFSL Berhampur after examining duly sealed.
Yes.
I handed over thereafter. I handed over the brass seal to G. Maheshwar Rao to produce before the court during trial on execution of Jimanama. Then, my lord, may kindly see the evidence of PW5. G. Maheshwar Rao. First paragraph.
Yes.
Police.
Yes.
Police Babu had not given me in Jima any brass seal.
But he kept it in.
Where he kept, and that was also not produced in the court. The evidence I am coming to that. I handed over the brass seal to G. Maheshwar Rao to before the court during trial on exam. I arrested the accused and produced before the.
Where you are reading?
I handed over
PW1.
PW1.
Yes.
I handed over the brass seal to G. Maheshwar Rao to produce it before the court during trial during on execution of Jimanama. This is the Jimanama. Thereafter, my lord, may kindly come. But then, my lord, may kindly come to paragraph 3.
Yes. Paragraph 3.
Paragraph 3 को आसिला मु एकाथर 40 एटा 50 टा गला पर paragraph 3 टा को आसिला non compliance of 42 पळे आसी. Paragraph 3.
Yes.
I detained the boss at 7:45 p.m. and relieved it at 6:30 a.m. I prepared the written report at 7:10 a.m. on 4/8/2003. It is a fact that I have not recorded the regions of search before entering into the bus after sunset and before sunrise. My lord, may kindly see
42.
42.
Yes.
Yes. 42. 42.
42.1.
42. No.
Me as officer.
Again.
The officer was
42. Then may kind of count the 42. A, B, C, D. Detain and search, and if he thinks proper, arrest any person whom he has reason to believe to have committed an offence punishable under this act. Provided that if such officer has reason to believe that such warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance, or enclosed place at any time between sunset and sunrise after recording the grounds of his belief.
Okay.
There must be total compliance of section 42, my lord. Partial compliance is no compliance.
PW1 para 3. PW1 para 3. Yes.
My lord. Then, my lord, how that PW 2 and 3, they are the independent.
42D proviso.
তারপরে 2-3 independent witnesses, they have not supported the case of the prosecution.
That's there.
My lord. Then PW 4 is also of no help to the prosecution.
42. 42.
PW.
Whether 42D proviso non-compliance is
Right.
mandatory or directory?
Yeah, is in the total compliance of section, there must be total compliance of section 42.
Show me.
I will give
show me.
this. I can give it. If partial compliance is no compliance, I will give also the citation. Would it be partial compliance, no compliance?
Yes.
Then I pointed out to my lord that the PW5 that the Boyasura, he stated that police babu had not given me in Jima any brasil. Therefore, the brasil was never produced in the court by the independent witness, my lord. Therefore, the
If there is the law is if there is a prior information and a search and seizure is going to be conducted, in that case 42D compliance is required. If while doing patrolling, if something is found, then 42D is not required to be.
if it, my lord says, if it is a chance recovery.
Come under section 43, not
Yes.
under section
42.
So that's 43. So therefore, this is a patrolling time. They have done it. So that is neither here nor there. You will not get benefit of it.
My lord. Let's see. Then my lord, may kindly see evidence of PW6.
6.
The investigating officer.
6. Okay. Yes. Yes.
PW1.
PW6.
PW6, paragraph 1.
Which,
On 4/8/2003, the occurrence took place on 3/8/2003 at evening, during evening time. On 4/8/2003, during morning, I was the SI of police attached to the Rayagada PS. On that day, IIC registered this case and directed me to take up investigation. In course of investigation, I took charge of the sealed ganja packet and sample packets from SI MSY who had detected the offense. I kept the seized ganja and sample packets in the PS Malkhana after making necessary entries in the PS Malkhana register, my lord. Then my lord may see the cross-examination.
yes.
Cross-examination, paragraph 2.
Para 4.
Para 2.
Para 2.
Again.
Yes. I took the physical charge of the articles
On
from
4/8/2003 at 7:40.
These articles were packed and sealed at the time of taking over the charges by me. I did not reopen the ganja packet. The Malkhana register is at the PS, and I have not sent the extract of the Malkhana
My lord.
entry.
The
of the
Malkhana register is at the
the
PS. I am
court.
not sent the extract of the Malkhana entry registered to the court.
statement of the
Therefore, the safe custody, it is settled in 2005 2LR Supreme Court. My lord, page 466. That it must be sent to the court
So,
to prove the safe custody.
show me the judgment.
Again.
Show me that judgment. You gave the citation, you have not read it.
I am ready in most drafting. The drafting allowed to the order like this. I will give the citations.
You are arguing an appeal. This is not that you will first you argue, thereafter you installmentally you do it. Come with all the argument. You have a very not so easy a case for you.
My lord.
Not so easy a case for you. Somewhere one line you read it and then write a judgment. Not like that. You have to read the evidence in its entirety. Some cross-examination, one line you have underlined and one judgment. If this is the way you argue, then I don't think you succeed. Come with the judgment, written note of submission, is a NDPS case, and sentence is there, and the prosecution has done a good job. It looks like in this case
I have a good also.
to create
My lord.
to create a dent in the prosecution case, you have to
My lord.
make an effort. ऐसे थोड़ी हो जाएगा. Already है, so everything is spotted. Come with judgment and written.
Yes, I'll get that. ଆପଣଙ୍କୁ 10 minute. And
Or in part. The entry mode will continue. Sir. Yes. 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 Entry mode will continue. Yes. Yes, madam.
after 10 days, my lord, I'm sure.
No, it will remain. Come. This will remain. Yes.
It will remain.
35.
Please, your lordship.
Yes.
Lordship, in this, the, I've been
35,
convicted.
huh? Yes.
Your lordship. Your lordship, I've been convicted under section 3(I)(12) of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. And the sentence is 1 year, your lordship.
And we need 1 year.
Yes, your lordship.
Yes.
Yes. Your lordship, the facts is that the victim is a laborer who was working under the accused, and they lived together, and a child was born to them. Thereafter, she belongs to the scheduled caste, where Exhibit 5 says that she belonged to the scheduled caste, but none have been there that the accused is of general caste.
Okay.
So there is no exhibit to such that. That is one point, your lordship. Now, your lordship, I'm harping on the point of Rule 7, your lordship. That Rule 7 of this act, your lordship. The Rule 7 of this
Yes.
act.
SCST.
SCST Act, your lordship.
Rule 7, huh?
Yes, your lordship.
Which
Yes.
Rule 7 of Rule
Rule 7, investigating
95.
officer.
95 rule.
Yes, your lordship. That who was,
Yes.
yes, your lordship,
Hmm.
investigating officer. An offense committed under this act shall be investigated by a
By
police.
the officer not below the rank of DSP.
Yes, your
Yes.
lordship. Yes, that is the thing.
Yes.
Your lordship, I will go through exhibit. I will go to the contentions of PW4 and PW5.
PW4, huh?
Yeah, your
Who
lordship.
is, let us see the final form, who has filed the final form.
Your lordship.
Oh,
PW3 is the victim.
no. Who has filed? DSP has filed, Balram
Yes, your lordship. But
Patnaik has filed the charge sheet.
who has conducted the investigation, your lordship?
Then he's a DSP.
Your lordship, kindly see, I will go through the deposition of PW4 and
Four,
PW5. your lordship.
PW4, okay. Yes,
PW4, your lordship.
yes.
On 9/9/99, I was SI of Police, Chhatrapur PS. On that day at 4 p.m., IIC received written report of informant and treated the same as FIR and registered the case under such and such and section 3(1) of SC and ST Act. I was acquainted with the signature and handwriting of the IIC NR Mohanty. This is the FIR received from IIC marked Exhibit 4. This is the endorsement with signature of IIC marked at exhibit. This is the formal FIR drawn by IIC marked. After registering the case, IIC directed me to take up the investigation. The IIC directed the SI to take the investigation, your lordship.
Okay.
In
In the
course of
course of
my
investigation,
investigation, I examined the informant and the witness, visited the spot and sent the accused and victim of to MKCG Medical College, Parampur for medical examination. On 99, after birth of the child, I sent the victim lady and her newborn child for medical examination and opinion regarding paternity of the child. I obtained medical opinion of the accused and the victim and opinion regarding paternity of the child. I obtained caste certificate from Tahsildar to show that the informant belonged to the scheduled caste community. Your lordship, it's one point that only the caste certificate of the victim has been obtained.
yes.
This is the caste certificate issued by Tahsildar as Chhatrapur marked at Exhibit 5. On 19/1/2000, as per the order of the SP, I handed over the charges to DSP, who submitted charge sheet, Your Lordship. I had examined Sukuru Pradhan.
Yes, what do you say?
In the
He said that I am SI, I have investigated everything, and after completion of investigation, I handed over the charge of the case to Deputy SP, who submitted the charge sheet. Investigation and everything is done by him. Very meticulously says, I did this, I did that, and all. The charge sheet is being filed by. This is not Rule 7. Rule 7 says that investigation has to be done by. That's the evidence of PWC.
I think the PSP was the
Yes. PW5, what PW5 says?
in the cross, Your Lordship, of PW4,
Hmm?
it is a fact that the para 4. Your
Para
Lordship.
4. Okay.
It is a fact that DSP has not separately recorded statements of witnesses and only tested the witness, examined me previously. So,
I visited the spot and everything is done by him.
yes, Your Lordship.
And examine Pradhan, I cannot, everything.
Yes, Your
5, let us see 5, what
Yes.
5 says.
5, Your Lordship. On 2000, I was DSP. The 99, everything has been done, investigation.
Hmm.
In 2000, he's the DSP. Homeguard Ganjam, Chhatrapur. On that day, as per the order of additional SP Ganjam, I took charges of investigation of this case from Chhatrapur, persuaded the CD and tested the witness and found sufficient material. And there is no, in the cross also it is written on.
And he only perused the CD and filed the charge sheet. That's
Yes.
all.
On 99 also, I was continuing as this homeguard. By the time I took over charges, investigation was already over, Your Lordship.
She
And made a final.
further damaging investigation is 5, just see, read 5, cross examination. Para 2. On 10/9/99, I also continued so and so. By the time I took over the charge of investigation, the investigation was already over.
And I made a formal investigation of.
This is not 7. 7 says that you have to investigate. You are convicted under only
Only 3.
SCST.
Yes, Your Lord.
I could. 7 is not complying.
she was 11/9/99 has been arrested. And it could be paid.
Undergone the sentence of
Civil.
493
So
was
that
there,
490
so
is there, so that.
so he remained in custody for a pretty long
But
time.
I'll pay.
What they don't know. If no unnecessary arrest taken, police does their
11 के बार चला
11/9/99 was
11
arrested
11/9/99
and released
arrested.
on bail on 20/10/2001.
2010.
2001. Bail bonds were served.
He's already undergone that period.
I will be acquitted. I pray for
But it's an
acquittal.
acquittal.
Your
This is a case of acquittal.
acquittal, Your
This
Lordship.
is a case of acquittal. What is this judgment 2003 SC 2612? It's written here. Mhm. But I have some of my judgments in this aspect. The investigation has to be done by the.
Yes, Your Lordship. There are other judgments also which I will give Your Lordship.
issue फटाफट छोटा सा सबमिट कर दो.
That's 493. That judgment is 490.
Hmm?
That 92 2001 so it is 490. 490 of this IPC.
हाँ ठीक है.
But this is
नहीं, he is only convicted under ACST.
Yes, Your Lordship.
But other charges are not true. ACST rule 7 is not complied. Simple. Thank you, madam.
Obligation.
Thank you, Dylan. Let's go. Yes. Ready? We'll hear it. 2 o'clock, something has to be left for 2 o'clock also.
2 o'clock probably a matter is fixed before your lordship, the Mr. Naik matter.
That I have heard already, there is nothing. He will give some citation. That won't take much time. You come.
Madam.
Well, 15, something. See.
So 15, my lord is very first to the specific, losses. I have again tried to establish that there is religion, respect of marriage when it comes to this case, that the fact begins from before the day of office. That is, the lordship may kindly continue to 52.
52.
DW1. So DW1, I did not really image that Sudha, right? DW1 is the only independent witness in this case. Out of 7 witnesses examined, he is DW1. Out of 7 witnesses examined, I have also got another decision also, but I'll cite it later, your lordship, when only family members, in the absence of any independent witness, when it is there, so let me read it, your lordship. What I had tried to establish begins from page 52. Right one, this judgment and this line.
Written note review.
They also will start looking.
Please keep. Argument heard. The parties to file their written note of submission along with the letter of appeal. No. That will go on simultaneously. If you are ready, it's argue. Otherwise, I'll put it on Tuesday. You are arguing something. 20? And I'll give it insofar you have been Tuesday. Yes. 27 of small material here. 27. Okay. Yes. 27. Then?
He surrendered on 24/1999 and it is not very exactly 8/99.
20?
24/1999 he surrendered.
20. 24 99. Surrender and 13/8/99. So then about 4 months. About 4 months. Huh? Shall I give PO? PO? 65 years, that's what is. Let us see these.
Statement of victim, my lord. P2.
He was 40 in the year 2000. That's what this indicates. Sentence is 1 year. 1 year sentence. हालत बड़ा खराब है. Array for 1 year and pay fine of 1,000. 1 month. 4 months he is already undergone. 350 or minimum. 350 for the
Age of the victim is 10 years.
When the offense has taken place? 99. No. The offense, the occurrence has taken place on March 99. March 99. October it came from 13. Huh? Nine years girl.
PW2 is doctor and PW4 is victim.
Let us see the victim. PW.
4.
What she says. 27. PW2. PW4, huh?
Yes, ma'am. Para 2.
A neighbor, huh? Mother was examined.
Mother of
PW.
PW3.
PW 3 also says the same thing.
Yes.
What is the reasoning given by the High Court, trial court? Let's see. Why 354? It is a penetrative sex. So then
Think
not there. Para 15, huh?
last person. Last four. Last four line.
Not at all visible. The next last argument is that half of the judgment is not visible at all. So this is all now the situation you would have been gone for life.
Yes.
So, now if the incident would have happened subsequently, it is life imprisonment. So where is the question of giving PO? PO, how 4 months only? And the evidence is, you see, medical evidence, let us see medical. Who is the doctor?
Doctor is PW2. Parathi is the opinion of the doctor. Cannot be ruled out.
See, it says that in the query of the police, the possibility of fingering in the private part cannot be ruled out. This is my examination. A 9-year girl. It's very heinous. 354. 354. And the- Now, after amendment, this amendment came 2013. 1 year is minimum. Earlier it was extendable to 2 years, or with fine or with both. Undergone about 4 months. Then fine has to be imposed. If PO, then under section 5.
65 years. I will also choose it. So I am after 69, I am the animal astronomy take information. His letter was written on consortment. Actually, document shows the statement.
POA. Section 5 of PO Act, if you see, apart from granting benefit of Section 4, you can impose fine under Section 5 without sending to custody. Come to Section 5. The power of the court to require release of an offender to pay compensation and cost. The court directing the release of an offender under Section 3 or Section 4 may, if think fit, make at the same time a further order directing him to pay such compensation as the court may think reasonable or loss or injury caused and so on so. And such cost of the proceeding of the court is reasonable. Amount order to be paid so and so recovered as a fine in accordance with the provisions of Section 386 and 387 of the code, and a civil court trying the suit and so on so. So I can impose and it will be recorded. Section 4 benefits. For benefit. It. Fine. What is the fine amount? I'll have to announce. I'll have to announce.
What the secretary has shown, actually, there will be
94, huh? 94 report movie, huh?
85
Will be, yes?
85 report समस्त
80, 85 and 94 report. Call for report. Take. Okay. Bring all this.